Okay, thank you very, very much for coming out. It's nice to see so many people at 9 o'clock on a Friday morning. We are delighted to have you here. Unfortunately, Dean Douglas couldn't make it. He is meeting with our foundation board all day today, but he has been a strong supporter of this conference and very excited that you folks have come. If I remember correctly, Pete, you can tell me, this conference came out of a lunch we had at the Polo Club.
It might be, yeah.
Maybe about a year ago or so.
We're
a little longer, yeah.
Months ago.
The gestation period, even longer than a baby, where we were discussing Pete's scholarship and the interesting turns it was taking. And we are very proud of Pete's contributions to this field and are absolutely delighted that other leading lights in the field have come to share their wisdom and insights with us. So this is just a great conference, and we're delighted that you're here. My job is to introduce Professor Steve Hansen, who is going to speak to you for a few minutes before the conference begins. He is William & Mary's Vice Provost for International Affairs. He's the director of the Wendy and Emery Reeves Center for International Studies, and he is also the Letty Pate Evans Professor in the Department of Government. Steve received his BA from Harvard University and his PhD from my law school alma mater, the University of California at Berkeley. His research expertise centers on comparative politics and communist politics, and he has authored books on post-imperial democracies and Marxism and the design of Soviet institutions. He's also, if you look at his webpage, the author of numerous book chapters and articles examining post-communist politics from a comparative perspective. Steve is also, as some of you might know, perhaps most renowned for being the husband of our super legal writing faculty, Jennifer Stevenson. We're delighted to have him here. I'm sorry, I have meetings all day, so I don't even get to stay. I'm really bummed about that. But Steve, come and share with us, and thank you for being here.
Thank you, Nancy. Thank you so much, Nancy, for that really kind and generous introduction. Welcome to everybody, faculty, students, distinguished visitors from around the country. It's really an exciting day today. This is a very important topic. You may be wondering why an international vice provost is making introductory remarks right now. You see on the program it was supposed to be Provost Michael Halloran. There is both a practical and, I like to think, an intellectual reason for this. The practical reason is that Provost Halloran is actually at the White House today. He is celebrating the award of the largest financial award to the College of William & Mary, and we think in the history of the college, $25 million over the next 5 years to the Aid Data Center for Development Policy, which is William & Mary's center to discuss and analyze foreign aid effectiveness around the world, one of our leading research institutions here. And USAID has decided to partner with us and a select number of other institutions to improve aid policy in the U.S. and around the world and find more effective solutions to spending those resources. So that's a very, very exciting development. And we decided that Secretary of State Clinton probably deserved, the attention of the provost. So we will hope, beg your forgiveness for that. So the Vice Provost for International Affairs is here instead, but I'm happy to report that the topic that you are discussing is, of course, of global and international significance. All over the world, debates about establishing the rule of law, which has become the stock phrase for it, are intersecting in a world where we increasingly think we don't necessarily have the autonomy as individual actors to select ethical principles. Instead, social forces or genetic or biological forces seem to be increasingly responsible for what we do. So the issue of how we inspire young generations to fight against entrenched autocracy or injustice or oppression for principles of the rule of law when people aren't sure that it's even possible for human beings to make free will judgments is actually a very topical one and one that is under discussion in a variety of cultures and contexts. As that introduction implies, what we're debating in the next few hours is a very old debate indeed. Free will versus determinism, what the meaning of justice is in that context is, of course, a debate at least as old as Plato's Republic and the debate between Socrates and Thrasymachus, with Thrasymachus famously asserting that justice is nothing more than the will of the stronger. And now the twist these days is that the will of the stronger refers to the stronger genotypes and phenotypes as opposed to the stronger physical specimens. But nevertheless, the debate is the same, and the response in many ways is still the same from those who oppose the idea that we can ultimately reduce law and justice to some kind of scientific or empirical basis, which is that there's something about the very words we use when we talk about justice and rights that simply is devoid of meaning or emptied out of meaning if we start talking about justice as the will of the stronger or something that is fundamentally empirical rather than principled, autonomous. This, of course, shows up in a lot of debates about free will and neuroscience today, where you notice a kind of funny sleight of hand in many of the articles and books that take the strongest position that free will is simply an illusion, that we are forced to grapple with our own heteronomy. At the very end of the article, there's often a phrase that says, and by the way, if it's true that we're not responsible for our own actions, we probably shouldn't punish criminals so severely. Except if we're not responsible for our own actions, then we can't really blame the punishers either, or for that matter, the analysts who are making judgments about whether there's free will or determinism, or for that matter, me in making this speech. The pressure's off, actually. I realized that this morning as I was penning these remarks, and I got more relaxed about it. So we're stuck a little bit, aren't we, between science and ethics, between heteronomy and autonomy. We're stuck in a way where we've been for several centuries, ever since Kant's critique of pure reason and critique of practical reason, by which he meant moral, left us with the idea that there's really kind of two spheres out there of judgment, and they're in some way incommensurable. The sphere of scientific reasoning, and Kant said this too, is one where we accept time as linear, we accept cause and effect as inexorable, we assume that there is no way for time to loop around or go backward, and that's why we can say X causes Y. And then the sphere of moral reasoning is one in which we assume time is irrelevant, we can make universal judgments, we can reflect as if there were no time and no determination, and then decide what is moral in the abstract. That has to be an axiom, an a priori assumption, according to Kant, and any amount of scientific reasoning doesn't get rid of that kind of philosophical starting point or reality. The problem, of course, is we're now reaching a point in the 21st century where our scientific knowledge of ourselves is so much greater than it was in Kant's day or for the last 250 years, that it's harder and harder to make the case that this two-sphere solution really holds up. When we know exactly what regions of the brain are firing when people are making moral decisions, how do we say, but at the same time, there's a sphere of timelessness in which we can reflect, a sphere in which we can make judgments that are devoid of any kind of empirical starting point or scientific reasoning? We seem to be having to make both logical and mental operations in a simultaneous way whenever we look at human beings making actual decisions or judgments. I think that is an interesting starting point for what I expect will be an incredibly rich debate today, which I'm looking forward to. I can say this much, though, so I can't resolve it, but I can say William and Mary is the place to hold this debate. And I think that is true for a variety of reasons. One is that this is a college, as you well know, that was really founded on exactly the principle that we needed to understand both science and morality, religion, and classical understanding in order to have a fully fledged education. From the founding of this institution to the present day, it has preserved the idea that liberal arts and philosophy and classics and religious studies are at the core, even as we push forward into the boundaries of scientific understanding and cutting-edge research on the human condition, which we also do here at William and Mary in a first-rate manner. So it's great to have a place where we can discuss this with mutual respect from both sides of the aisle in a way. A second reason to have this conference at William and Mary is that we are small enough to break down the silos that typically divide researchers and scholars on either side of this issue. I think one reason for sometimes an intolerant tone that emerges on one or another side of the debate between moral theory and science and neuroscience is that people are in departments or even schools that are so separated from each other in vast universities that they never really speak across the divide. Whereas here at William and Mary, as you can see from the organizers of this conference, we have the Institute for the Bill of Rights Law, we have psychology, we have philosophy, we have religion, and we have the neuroscience program, all collaborating, even international studies, collaborating to hold an event which asks the tougher question about how to resolve or move beyond this particular divide. And finally, we are a global institution. We're an institution that has never forgotten that the debates that go on about free will and determinism don't take place only in Virginia or only in the United States. They are, in fact, global debates, as they were for the Founding Fathers and as they remain to this day. So the debate we have today is a reflection of something that is, in fact, going on across the world, both in the scientific community and in the community of law and moral reasoning. So with those reflections, I'd like to introduce the conference, and let's start the first panel. Thank you very much.
Thank you very much, Dr. Hansen. And we are particularly grateful to the members of the broader college community for coming together, for joining us from psychology, philosophy, religion, neuroscience, and some of their students and faculty members. But I'm also particularly grateful to the Bill of Rights Institute and its director, Professor Neil Devins, who has provided substantial financial and logistical support. Melody Nichols of the Institute, with the assistance of my graduate research fellow, Rachel Cannon, brought all of this together and kept me as calm as they could so far. When the dean offered me the opportunity to put this program together, I knew right away that I wanted to invite 4 scholars whose work I greatly admire and share them with you. This really is not a debate, though I suspect it may evolve into such. Just really presentations of 4 particularly distinguished legal theorists and me who happen to hold differing views on a fundamental issue, an issue crucial to law's operation, the nature of the human agent. There is opposition of the natural and the supernatural, and as well difference of opinion on the promises and threats presented by the more materialistic perspective. The 2 panels today are loosely organized around themes. The first panel will consider perspectives on why we are constituted as we are, the product of supernatural or evolutionary or ultimately wholly materialistic forces, best explained by reference to neuroscientific insights. We will, after the first panel, take questions from the audience, and perhaps there will be conversation among the panelists. Then a brief break, and a second panel will consider perhaps the legal context most obviously dependent on conceptions of human agents' responsibility, the criminal law. And then again, we'll have time for questions. I'll lightly moderate, briefly introducing each speaker. I, of course, require no introduction. So we can get started with the first panel. First, Professor Stephen Smith is the class of 1975 endowed professor of law at the University of San Diego's Law School. I have read and studied Professor Smith's 2 most recent books published by the Harvard University Press, Law's Quandary and the Disenchantment of Secular Discourse. Oh, I like my title.
Yeah.
Okay.
That'll be the next. That's the sequel.
Okay. That's the sequel. Well, that was, but I'm not allowed to study them at home anymore. Because when I'm reading Steve's work and I stand up and shout, no, 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 it disorients the dog and upsets my wife. Steve writes about provocative subjects provocatively, and you find yourself agreeing. No, I cannot get that out of my. Okay. And you find yourself agreeing with him more than you think you should. He is one of the leading legal scholars of our generation. Steve.
Thanks a lot, Pete. I'm gonna.
You would say
I should go.
if you could. Yeah.
Well, all right. The only difficult.
Just don't pace to your left because then the camera loses you.
All right, I'll stay here. The only problem when you're tall and you're becoming a little bit hard of sight, a podium like this is sometimes a little difficult. But I'll see if I can negotiate this. I really do appreciate being here, and I look forward to the contributions of the distinguished contributors. I think I probably should begin by acknowledging the obvious question, which is, what on earth am I doing here? That, I think, is actually always a good question to ask, but it's especially pertinent in this particular instance. This is mostly a conference about neuroscience and its implications for the human agent or the person and for law. Now, as it happens, I know a little bit about 1 or 2 areas of law, and I know a little about persons. I even audaciously claim, or at least aspire to be one. But I have to admit that I'm pretty much completely innocent when it comes to neuroscience. I mentioned this deficiency to Professor Alces when he invited me to come, and he suggested that it was precisely this lack of a scientific orientation that qualified me to participate. It would be good to have a contrasting perspective, one that was a little more traditional and less entrenched in current scientific methods and assumptions. I notice also that the program describes me as someone who takes, quote, a traditional approach to an ancient dilemma. Now, I'm not entirely sure exactly which ancient dilemma is being referred to here, but whichever one it is, I probably do take a traditional approach to it, if I approach it at all, that is. So I really want to thank Professor Alces for generously including me in this conversation, and I look forward to learning from it. In preparing my comments also, then I've conscientiously refrained with only an occasional and inconsequential lapse from doing or reading anything that might compromise my main credential, which is my scientific innocence. I'm going to present my view in 3 stages. First, I'll try to describe what I'll call the everyday conception of the person. Then I'll notice how questions within this everyday view give rise to some standard or traditional debates in philosophy and also in theology. Just in case you might be harboring any unrealistic expectations, let me hasten to say that I won't be offering any resolutions to those debates, of which I'm no more than an occasional spectator. I will suggest, though, that for the most part, with an important qualification that I'll notice, the debates don't negate or seriously threaten the everyday conception of the person. Finally, I'll explain why I expect that advances in neuroscience, however impressive and illuminating, will leave philosophical and theological debates, as well as the everyday view of the person, pretty much as they were. So let me start with the everyday view of the person. When we talk about persons, our credentials are different and, in an important sense, stronger than they are when we talk about neurons or atoms or germs or even about shoes and ships and sealing wax. In the matter of persons, we have the enviable advantage that the subject matter is something we observe directly with at least 4 of the 5 senses pretty much every day of our lives. Indeed, we have the further and considerable advantage that we actually are persons. So we know persons, or at least one person each, inside out, so to speak. In this respect, our expertise and authority to pronounce about persons exceed the expertise and authority of scholars or scientists to pronounce on other more estranged subjects. And on the basis of this expertise and first-person experience, most people develop a basic, unrefined understanding of what a person is, an understanding that typically includes most or all of the following characteristics. So we think that human persons are formed by some conjunction of physical substance and mental qualities. Persons have bodies, and they also have minds. We often describe the contents of those minds in terms of some familiar mental states or operations. Descriptions will differ, of course, just as descriptions of the night sky or the weather will differ, but some features figure on most lists. Thus, persons have consciousness, or at least the capacity for consciousness. Within or upon that consciousness, more specific mental states or operations occur. Persons perceive, they intend, they think, they understand, they believe, they choose, they feel. I say that they have these qualities, the persons do, although it would be more accurate to say that we persons have these qualities, or maybe even that we are these qualities. We're constituted as persons by them. So we could say that the everyday view holds that a person is a conjunction of body and mind, and that mind includes the features of consciousness, intentionality, and so forth. Sometimes this view is described as a kind of folk psychology. I wonder whether that description may be unduly depreciative. In any case, it's important to appreciate how solid, even if unsystematic, our everyday knowledge is of these mental features such as consciousness, intentionality, etc. We may not organize and test our knowledge of the person in any methodical way, and yet we know these things, consciousness, intentions, choices, and so forth, more directly and surely than we know anything else, and we know other things only at one or more removes and by means of these mental features. Or you might think about the matter with reference to Descartes' famous cogito, I think, therefore I am. It may be that the argument goes astray promptly after that first step. The supposed proof of the existence of God and the argument that God would not allow us to be thoroughly deceived about the external world may seem unpersuasive to you, as they do to me. But the first step, that I think, which is a proposition that I affirm even in trying to deny it, and if I think I must exist in some sense, it seems compelling. And the I that's thereby demonstrated is, as Descartes explained, a thing that thinks. Our mental existence, in other words, seems more demonstrably undeniable than even our physical existence. A different feature of the everyday view of the person, namely continuity, also needs to be noted. This feature seems to me less obviously observable and less impervious to denial than the mental states I've been discussing, such as the fact of consciousness. And yet we surely do have a sense that persons exist over time, at least during the period of our natural lives. I look different, and I talk differently, and believe differently, and yet I'm in some real sense the same person who had Miss Thomas as a teacher in the first grade, and who rode the bench on the basketball team in junior high, and who worked at Cravath, Swain, and Moore for a summer during law school. People can change quite drastically in various ways, but we think that in some essential sense they're still the same people they were. Our language reflects this belief, even when we seem to be denying continuity. He's a new man, we say, but the he still connects and unites the old man and the new man. Otherwise, the observation would lose its sense, and we would just have two different men. These features of the person as understood in the everyday sense are obviously important to law and to law's conception of human agency. If a tornado lifts your body off the ground and throws it against someone, you will not be guilty of any crime. But if you intentionally run into someone, you may be convicted of a felony. And you can be convicted even though years have passed since the deed was done, and you've since switched jobs, switched spouses, and been born again. It's still you who did it, we think. Indeed, the everyday conception is ubiquitous in law. So we talk constantly about what the legislators intended, or what the defendant knew, or what the conscientious objector believes, or what sort of pain and suffering the plaintiff felt. Now, I was initially tempted to add a further important feature to the everyday conception of the person, namely intrinsic value, or inherent dignity, or something of that sort. This feature is widely accepted today, or at least given lip service, and it does sometimes seem to be almost as evident as features like mind and body, even if it's not a merely empirical quality directly perceived through the physical senses. If you get to know a person, we sometimes say, if you really look at her, look into her eyes, come to understand her hopes and dreams and fears, you apprehend something deeply precious, something of infinite worth, as we sometimes put it. I admit this procedure may work better with children, by the way, than with teenagers or colleagues in faculty meetings or presidential candidates. Others try to get to the affirming conclusion by starting with the immediate apprehension of our own worth, which is something that we evidently are somehow supposed to just know or assume, and then doing the Kantian quick step of universalizing. I know I'm valuable, and I can't identify any morally relevant distinction between myself and everybody else, so everybody else must be valuable too. In the end, though, I don't think we can count this quality of intrinsic worth as part of the everyday conception. However widely a belief in intrinsic worth may be professed today, it doesn't necessarily or automatically arise just from the experience of oneself and others. David Bentley Hart argues that this conception of persons as intrinsically valuable is a Christian contribution to Western thought. I'm not sure if that's so, but be that as it may, the belief appears to be a culturally contingent commitment. And if you don't already have the commitment, I very much doubt that the Kantian-type logic will or should lead you to it. Even so, I think we can say that the belief in intrinsic value is connected to, or perhaps dependent on, the everyday conception. It is, after all, persons conceived as having minds and the capacity to choose, intend, believe, and feel, who we think have intrinsic value. Take away these features, reconceive persons as complex organic androids, and the commitment to intrinsic value might come to seem wholly unwarranted. In sum, intrinsic value seems to be, if not a component of the everyday conception, at least a satellite of that conception. And the commitment to intrinsic value is, of course, important to law in all kinds of ways. In the justification of human rights, for example, and in the due process and other legal protections that we deem necessary even for convicted criminals. If a robot malfunctioned and began to hurt people, we wouldn't hesitate to disable or dismantle it. We don't do that even to sociopaths because we think they're persons or people. Now, for most practical purposes, legal or otherwise, the everyday view of the person serves us pretty well. But situations can arise or questions can be posed that challenge the everyday view, or at least that go beyond its jurisdiction. These questions have given rise to a number of familiar philosophical debates, which often have their theological counterparts. Perhaps the most basic of these debates involves the so-called mind-body problem. In the everyday view, a person has both a body and a mind. But how are these seemingly quite different entities connected? It seems that mind and body interact, but how exactly does the causal relation work, and which way does it run? Does mind control body, or is it the other way around, or maybe a bit of both? Those questions point directly to another perennial debate over what we often call the question of free will versus determinism, already been noted today. We surely have the subjective experience of making choices. But are those choices real or merely illusory? If a choice is caused by something else, is it really free? But conversely, would an uncaused choice, if that were possible, really be a choice at all, or merely something more like an arbitrary spasm of will? And then there's the question of personal identity. It might be, for all I know, that between the ages of 6 and 60, most or all of the cells in my body have been replaced by other cells, many times over, maybe. So on the physical level, there's little or nothing left of the organic blob that slumped day after day in a desk in Miss Thomas's class. Maybe most of my beliefs and commitments have changed as well. So what justifies saying that I'm the same person I was then? These well-known philosophical debates have their theological counterparts. What is the soul, and how does it fit into the mind-body schema? Are people free, or are they predestined to good or evil, to salvation or damnation? If Joe or Mary are resurrected or reincarnated, in what sense are these newly resurrected or reincarnated beings the same Joe and Mary that we knew and loved in this earthly life, and so forth? The perennial debates seem unlikely to be definitively resolved anytime soon, or maybe ever. My colleague Larry Alexander, whose philosophical expertise greatly exceeds my own, thinks that the debates grow out of fundamental antinomies that defy resolution in terms of our limited human concepts and categories. That sounds about right to me. For our purposes here, though, The most urgent question is whether the philosophical debates give us reason to relinquish the everyday conception of the person, which, as we've seen, is vital in so many ways to law. With respect to that question, it seems to me that the possibilities fall into three main categories. First, philosophical reflection might confirm or reinforce the everyday conception, perhaps refining or clarifying it in the process. Second, philosophy might lead us to suppose that the everyday conception, though not exactly true, is nonetheless valuable and worthy of being maintained, perhaps as a sort of useful fiction or illusion. It might be that, as Saul Smolanski asserts, our priority should be to live with the assumption of libertarian free will, although there is no basis for this other than our very need to live with this assumption. But as we cannot accept this way of seeing things and confront dangers to our beliefs, illusion must play a central role in our lives. Finally, philosophical reflection might lead us to conclude that the everyday conception is simply false and that there's no good excuse for continuing to maintain it. It's only this last possibility, I think, that would obviously have seriously disruptive implications for law. But this risk seems to me minimal, at least for the core features of the everyday conception, namely the existence of mind as well as body, and hence of mental states such as intentions and choices and beliefs. That's because, once again, we know these things more immediately and surely than we know anything else, and our very ability to philosophize presupposes them. So you may not be able to say exactly what the causal connection is between your thoughts or your intentions and your brain states. It doesn't follow that you don't have thoughts and intentions, or that these thoughts and intentions are illusory, whatever that might mean. To be sure, even before philosophers come along, the everyday view occasionally finds itself challenged and sometimes stumped. This kind of puzzlement may well be what generates the philosophical debates. And this sequence can occur in law. Thus, we have the standard conundrums of criminal law: insanity, mistakes of fact, duress, and such, for which philosophically oriented theorists attempt to provide solutions or at least clarification. The important point for present purposes is simply this: the everyday view's difficulties in answering such questions show that the view is limited, not that it has somehow been refuted or shown to be mistaken. More generally, the difficulties posed by the perennial philosophical debates don't require or even give us any very good excuse for resorting to the kind of reductionism that would dismiss core components of the everyday view as mistaken or illusory. This is a common temptation, I think, to be noted and resisted. If we're vexed by the difficulty of figuring out how mind relates to body, we might be tempted to banish the problem by reducing one of the terms into the other. These days, we would most likely reduce mind into matter, though we could also go the other way, reducing matter into mind, after the manner of Berkeley. But except for the desire to wish away a hard question, there seems to be no very good reason for either of these reductions. In this vein, Thomas Nagel notes that reductionist and behaviorist accounts of mind have been, quote, fairly common among contemporary philosophers, but the only motive I can see for them is a desire to make the mind-body problem go away. None of them has any intrinsic plausibility. In actual practice, both the everyday view and the perennial debate seem to flourish side by side without unduly treading on each other's turf. Philosophy seminars address the mind-body problem, or the problem of free will, or personal identity. Because the seminars involve human beings, the everyday conception is naturally present, even ubiquitous, within the seminar room. People ask what other people believe, or what they mean, or what they intended to say. The professor gives a final grade on the unquestioned assumption that the mind-body composite going under the name of Jones, who took the final exam, is the same person as the Jones who forgot to turn in the first week's assignment. This presence of the everyday conception does not inhibit discussion of the philosophical questions. If the everyday notions come into the seminar room, the converse is also true. Philosophy occasionally makes its way out into the non-academic world, where it may provide some illumination or at least stimulate engaging conversations. In law, philosophy may occasionally help to clarify a concept or an issue, in criminal law, for instance, or tort law, or constitutional interpretation. The value of such clarifications may be debatable. Still, we everyday types can be humbly grateful for whatever illumination is forthcoming. On the whole, though, philosophy's contribution is to clarify or refine the everyday notions for legal use, not to negate them. As we move farther from the core of the everyday conception, this confidence seems less warranted. In particular, the commitment to the intrinsic value of every individual is one that, as I've said, seems connected to the everyday conception, though not exactly part of it. So it is entirely conceivable that someone might conclude, without any logical inconsistency, that persons exist and that they have minds and bodies and intentions and so forth, but that these qualities don't make them any more intrinsically valuable than cows or crows or crustaceans. In this respect, let's see if I can turn my page here. No. In this respect, philosophical reflection could challenge and unsettle one corollary of the everyday conception, along with its implementation in law. Although my impression is that, at least for the moment, most secular political philosophers are disinclined to make or even perhaps seriously acknowledge that particular challenge. Among theoretically inclined scientists, attitudes may be different. So now at last we come to the central topic of this conference. Does neuroscience fundamentally alter this state of affairs, either for philosophy or for everyday understandings? Now these are large questions, and my own views won't and shouldn't carry much weight. As I've already confessed, I'm largely innocent of neuroscience, and of course I'm not a philosopher either. Here I am, though, so for what it's worth, my own view is pretty complacent. I think that for the most part, neuroscience doesn't and shouldn't radically alter the situation, either in the realm of philosophy or theology, or in the everyday domain. Now, I realize that there are people who think neuroscience will transform understandings in philosophy, perhaps resolving the perennial debates, or perhaps displacing or dissolving them, or that it will gravely threaten everyday commitments to things like free will, intentionality, and so forth. For my part, I see no warrant for these sanguine or dire predictions. In saying this, I don't mean to doubt or diminish in any way the achievements or the potential of neuroscience. People closer to the field obviously differ in their assessments of how much the science has already achieved or is eminently capable of achieving. Some, like Professor Alces, seem quite bullish, while others, like Professor Morse, seem more skeptical. At least for purposes of argument, though, I'm willing to indulge the most wildly optimistic view and to imagine that neuroscience will very soon offer us a complete and completely trustworthy understanding of how the brain works and of how objective brain states correlate with the various subjective mental states that we directly experience, such as intentions or beliefs or choices. Would this knowledge resolve or dissolve the philosophical debates? I don't see how. Would it somehow show the everyday conceptions to be mistaken or illusory? I don't see why. Now, in defense of this complacency, let me offer two observations. First, we've known all along, I think, that there's an essential connection between mind and body, and thus between mental states and brain states. I don't think anyone can have doubted this fact for a good long time, if they ever did. Consume alcohol or ingest a hallucinogenic drug, and your consciousness and mental operations will be affected, perhaps drastically, at least so I'm told. Stay up at night, all night, and come down with a high fever, and your thinking is likely to become murky or meandering. Some people will suppose these facts count in favor of determinism. Whether that's so, and whether this sort of determinism would be incompatible with free will, are questions that philosophers have long debated. But it was all along to be expected that science, as it progresses, might provide more detailed or accurate accounts of the physical processes by which these and similar effects occur. I simply don't see how more detailed understanding of something we've known and accepted all along should compel us to change our fundamental views of the person. Or put it this way, there may be accounts of mind or free will or personal identity that would be seriously threatened by a better understanding of the brain, but those, I suspect, would not have been the accounts that were worth defending anyway. Thus, as science and neuroscience advance, the philosophical questions about mind and body and free will and personal identity seem as real and contestable as ever. And as I've said already, the philosophical debates seem for the most part to leave the everyday conception undisturbed. My second point repeats an argument I've already made. What we know most immediately and surely is the fact of consciousness and of the mental states that occur within our consciousness. Other subjects within our knowledge, even the directly observed external world of tables and chairs and law books and so forth, are a step or 2 or 10 down the epistemic road. So it seems to me curious when people, on the basis of supposed empirical evidence, or perhaps philosophical considerations, come to doubt what they know more immediately and what is presupposed in their reflections on the empirical evidence or the philosophical considerations. Put differently, a person who says something like, "I believe that mind or consciousness is unreal or illusory," seems to me to be talking rank incoherence. The reality of mind and consciousness, I would think, are a precondition for your being able to believe anything at all, or to present your belief to someone else whom you evidently deem to be cognizant and capable of understanding your presentation. I think the same conclusion would hold, by the way, if we were to ask about theological questions. Just what the soul is, or whether it's predestined, or how it relates to the body and the mind, or whether and how it can experience resurrection or reincarnation, are all tough and contested questions. Many people, myself included, believe in the soul. Many other people don't. I doubt that neuroscience will settle this sort of disagreement one way or the other. To be sure, the soul is not a particular lobe in the brain. It's not the sort of empirical entity that scientists will be able to observe with their instruments. To conclude from this that people don't have souls seems to me approximately as cogent as saying that because scientists have looked through their telescopes and not observed God flitting around somewhere up there in the Crab Nebula maybe, they have thereby proven the truth of atheism. Here's one oblique qualification to my main argument in this section, though. I've already indicated that the commitment to the intrinsic worth of persons, which is not exactly part of the everyday conception of the person, but is associated with that conception, is potentially vulnerable to philosophical reflection. It may be that neuroscience will undermine their belief in intrinsic value as well. Suppose we come to believe, as neurobiologist Jean-Pierre Chengeau confidently declares, that, quote, the brain secretes thought as the liver does bile, and that beliefs are no more than, quote, a specific state of nerve cell activity that, like diseases, quote, can propagate from one brain to another and spread infection much as viral attacks do. Or suppose we come to believe that, as Daniel Dennett asserts, we are each made of mindless robots and nothing else, no non-physical, non-robotic ingredients at all. Notions about intrinsic worth might then come to seem like quaint superstitions. And we might conclude, as Dennett elsewhere says, that we must give up our awe of living things. I suspect that Professor Alces may be making a related point when he says that when we understand persons and morality in evolutionary and naturalistic terms, the magic goes out of our morality. Now, on this particular point, Chengeau and Dennett and Alces may be right on a purely descriptive level, but even then I think the threat to intrinsic value seems more indirect and atmospheric, you might say, than strictly rational. A better understanding of how the brain works and how it causes or correlates with mental states doesn't in itself tell us anything about whether persons have intrinsic worth, so far as I can see. Neither does an account of how persons may have evolved from other organisms. But it is possible that by giving more cachet to a naturalistic approach to understanding, advances in neuroscience and evolutionary psychology might contribute to the ascendancy of a worldview, or as I sometimes put it, an ontological inventory, in which things like intrinsic value don't register. In this way, it's conceivable that neuroscience might, for some people, undermine belief in intrinsic value, in the same way that for some people, science undermines belief in God. Not by scientifically demonstrating that God or intrinsic value aren't real, but by promoting and reinforcing a vocabulary and a conceptual framework or ontological inventory in which these things just don't figure. Some people will find this loss of faith in soul or intrinsic value invigorating. They'll feel that their newfound skepticism is an indication of their tough-mindedness or of their keeping up with current knowledge. That's fine. The sad thing, I think, is when someone announces this loss of faith regretfully, because the sacrifice is, so far as I can see, pretty much gratuitous. For the most part, you will have noticed, I don't see neuroscience as threatening the everyday conception of the person that informs so much in our law. Now, the happy implication of this complacency is that we should feel free to encourage and appreciate neuroscience while going on with our everyday pursuits, including our legal pursuits, and also with our philosophical and theological debates and reflections, if we're engaged in those, pretty much as before. Neuroscience, no doubt, will provide illumination regarding a variety of matters for which we can be grateful. It may also provide other practical benefits, including in the practices and operations of law, and for these we may be grateful as well. Maybe neuroscience will help improve methods of diagnosing and treating psychological conditions associated with crime, for example. Maybe technologies associated with neuroscience will give us better ways of measuring pain, suffering, and anxiety, injuries that are important in litigation, but are pretty much impervious to objective measure or verification at present. On the darker side, there may be dangers or ethical problems associated with neuroscience. I'm not prepared to say just what these might be. My modest suggestion is that we need not be hindered by a concern that the kind of knowledge delivered by neuroscience will deprive us of the basic notions of personhood, agency, and value or dignity on which our everyday activities and our legal institutions depend. Thanks.
Our second speaker is Professor John Mikhail, a professor of philosophy and law and philosophy, I should say, at Georgetown's Law Center. He studied with Noam Chomsky and has developed a theory of the values instinct, which is redolent of Chomsky's language instinct. It may rightly be said of Professor Mikhail that even very early in his career, he has produced work that will change the way people think. John Mikhail has also written the only PhD dissertation that I have ever read all the way through, and I've read it twice. He continues to teach me. Right up here. it's dark is what we're doing. Let me see, if I can get some more lights.
Launch this. Let me see if I can.
Oh, I think that's okay.
Pete.
That's dark? Okay. Is that visible?
Well, thank you very much. Let me begin by thanking Pete and the other organizers for including me in this conference. It's a real honor and privilege to be here. I want to begin by affirming that I do believe in free will, and so the pressure is on. And also to clarify that I'm not a neuroscientist. I come out of work mostly in the cognitive sciences, but I do have some modest knowledge of certain parts of neuroscience that bear on my topic. I also am not going to be talking directly about the free will determinism debate. The research that I do is sort of tangential to that debate, although related. It has to do more with the way in which human beings make moral judgments rather than choose how to act. And I'll try to say something about the relation between those two aspects of behavior as I go along. And the last just preliminary point I wanted to clarify is that what I've gathered so far from the discussion that's gone before and also general discussion about neuroscience and law, there's a general impression that neuroscience is going to debunk common sense or ordinary morality in some sort of way. And there is plenty of work that gives off that impression. I wanted to clarify that my own research is actually oriented toward a different objective, which is more to vindicate ordinary common sense morality, although to do so in what I hope is a nuanced and balanced way. So those clarifications. Let me begin with a quote from Charles Darwin, which I like very much. Darwin devoted the third chapter of his book, The Descent of Man, to the origin of the moral sense. And he makes 2 points in the chapter that I think are quite important to begin with. One is that he fully agrees with the judgment of those writers who maintain that of all the differences between human beings and the lower animals, the moral sense or conscience is by far the most important. So a strong affirmation of the distinctiveness of the human moral faculty, moral sense or conscience. However, Darwin also adds this famous remark. He says that from the perspective of evolution, any animal whatever endowed with well-marked social instincts would inevitably acquire a moral sense or conscience as soon as its intellectual powers had become as well developed or as nearly developed as in man. So an affirmation of the continuity of human moral capacities with the rest of, or with other species. And those are good starting points for the conversation I'd like to have today. So Darwin was writing at the tail end of a period that I like to refer to loosely as Enlightenment rationalism. And this prescinds from debates between, or distinctions between rationalists and sentimentalists, as they're sometimes studied in philosophy. What I mean by Enlightenment rationalism is an approach to human moral cognition that has at least the following features. It's committed to methodological naturalism. And by that I mean an approach that studies the contents of the human mind in more or less the manner that we would study the operations and the contents of the human body. So the opposite approach there would be methodological dualism, that somehow, from a scientific perspective, we study the mind and the brain differently than we do the body. The thinkers to whom I'm referring, by and large, held that human moral judgment had the following properties. It was what today we would call computational. It had a kind of a rational inferential basis. The operation of moral judgment was held to be unconscious in important respects. The first principles of morality were thought to be non-introspectable. And the system was thought to have an innate basis of some sort, some kind of natural foundation. By that, I simply mean that the system doesn't derive its properties exclusively from the environment or from culture. There's some contribution from the organism's own intrinsic program. In addition, the human moral capacity was held to be a species property, something that all human beings possess, all normal human beings apart from pathology and the like, and that only human beings possess. And this system, this innate moral faculty or moral sense, was held by legal thinkers to be the foundation of what was called natural jurisprudence, or the jus gentium, the law of nations. So that's an important connection. From a more modern perspective of evolutionary psychology, we might say, loosely again, that what we see when we look back to Enlightenment rationalism is the anticipation of what today sometimes goes under the rubric of the identification of domain-specific evolved algorithms, or Darwinian algorithms. So whereas many of these 17th and 18th century thinkers might have thought or said that the moral sense was implanted in the human being by God or by some divine source, today we would substitute evolution or some sort of naturalistic explanation for that. That said, many of the observations and the arguments that were made, I want to suggest, about the properties of the moral sense look to be sound, or at least plausible, and worth consideration. So let me just give you a little bit of a flavor of this history before turning to modern research. Most of the leading thinkers of the Scottish Enlightenment reacted to Hobbes's famous declaration and argument in Leviathan that that justice and injustice are none of the faculties either of the body or the mind. That's the way Hobbes put it in chapter 13 of Leviathan. It followed from that the state of nature was a war of all against all, and that justice and injustice do not exist in the state of nature. We need a positivistic legal origin for those kinds of concepts. Well, the Enlightenment rationalists to whom I'm referring, and in particular the Scottish Enlightenment thinkers, rejected this contention quite vigorously. So Francis Hutcheson argued that the several rights of mankind derive from a natural moral sense of right and wrong that's natural to us previous to any consideration of law or command. David Hume is not usually classified as a rationalist, but in the sense that I'm using the term, he falls under the category. And Hume was a naturalist universalist about the moral sense. He says that the final sentence which pronounces characters and actions amiable and odious, praiseworthy or blamable, probably depends on some internal sense or feeling that nature has made universal in the whole species. And Adam Smith, in his treatise Theory of Moral Sentiments, Before the Wealth of Nations, excellent book to which I commend you, says that to refute the odious doctrine of Hobbes, it was necessary to prove that antecedent to all law or positive institution, the mind was naturally endowed with a faculty by which it distinguished in certain actions and affections the qualities of right, laudable, and virtuous, and in others those of wrong, blamable, and vicious. This is the view that I hope to persuade you is at least plausible from a contemporary cognitive science perspective. Very briefly, those ideas that I just presented were deeply influential in the philosophical background of the founding of the American democratic system. People like Jefferson and Wilson and others were significantly indebted to the Scottish writers in particular. So Jefferson, William and Mary graduate, says, Hobbes believes that justice is founded on contract solely and does not result from the construction of man. I believe, on the contrary, that it is instinct and innate, that the moral sense is as much a part of our constitution as that of feeling, seeing, or hearing. The moral sense or conscience is as much a part of the man as his leg or arm. And James Wilson, who's a particular favorite of mine, one of the most influential founders in terms of how the text of the Constitution was actually written, wrote that the moral sense is a distinct and original power of the human mind. Our knowledge of moral philosophy, of natural jurisprudence, of the law of nations must ultimately depend for its first principles on the evidence and information of the moral sense. And finally, early feminist thinkers like Mary Wollstonecraft, I think, also held similar views about the species characteristic of the human moral faculty. The key point being that this is a human moral faculty, not a male moral faculty or something possessed by only part of the human race. And it's for that very reason that the same principles apply to all people, not just to men or white men or different categories. Well, let me now fast forward to contemporary research. As Pete mentioned, my own research sort of draws from a very traditional analogy between rules of justice and rules of grammar, or the scientific study of human language and the scientific study of human morality. This is an old analogy that goes way back in Western intellectual history. You can find it, for example, in Aristotle's Politics, where he says that the sense of justice and the gift of speech are the two characteristics that distinguish humans from other animals. Cicero and other classical thinkers say similar things. And many writers in the modern period have drawn this analogy. So I'm not alone in thinking that there are interesting insights that might be gleaned by thinking of the nature and origin of common sense moral knowledge from the perspective of the study of human language. More specifically, my work draws from the work of Noam Chomsky and the linguists and cognitive scientists who have done research within his general framework. And following Chomsky, I distinguish 5 questions that a theory of moral cognition would like to answer. So Chomsky asks these questions, or the counterpart to these questions in the case of language. I ask the similar questions in the case of moral cognition. So we want to answer questions like this. What constitutes moral knowledge? When we say informally, pre-theoretically, that someone knows the difference between right and wrong, what do we mean by that? Can we unpack or explicate the meaning of common sense moral knowledge in a rigorous way? How is that knowledge acquired by each individual? How is it put to use in actual human conduct? And this is where the question of free will may enter the picture. And it's not a question that my own research has been directed toward. I'm interested in the first 2 questions primarily. What constitutes moral knowledge? How is it acquired? When we ask how moral knowledge is put to use, we have to draw a distinction right off the bat between perception and conduct. Intuitive moral judgment or perception, which may in fact be involuntary or deterministic in some respects, and what we do with that information. Once we've perceived the moral status of an action, how do we then decide to act? And that's where free will, I think, best enters the picture. And it's important to draw that distinction. In linguistics, this is the distinction between what's called the perception problem or the parsing problem and the production problem. Scientific linguists in the Chomskyan tradition do not try to make predictions about what people will say in certain circumstances, but rather how they will perceive the properties of utterances. And that's a fundamental distinction. And if we have good answers to the first questions, we might go further and then start to ask the neurocognitive and the evolutionary question. Once we have a description of the system, how is it realized, instantiated in the human brain? It may not be a single place. It may be instantiated in a more complicated way. The same way, for example, that the human circulatory system is not in any one place in the body, or the immune system. We don't get lost in debates about localization when we talk about those bodily systems. And likewise, it may be a mistake to simply assume that when we say there's a physical realization in the brain, there has to be a particular place in the brain where moral knowledge resides. That's a mistake. And then there's Darwin's question. How did this system evolve in the species? This diagram shows in a little bit more detail, although still sketchy, how the research program might unfold. So Chomsky distinguished 2 models that a linguistic theory must specify, a perceptual model and an acquisition model, and those are represented on the left-hand side of the screen. In his early work, Syntactic Structures, he really drove the direction of the research of the field by saying, look, the first question we have to answer is, how exactly do people distinguish grammatical from ungrammatical utterances? They're manifestly able to do that. How do they do that? What do we have to attribute to their minds to explain that behavior? And the answer to that is what he called a linguistic grammar. So Chomsky psychologized the notion of a linguistic grammar and located it in the mind in some manner. And in the top right-hand corner, the analogous question that we might ask in moral theory, or in legal theory for that matter, is on what basis do people actually go about distinguishing permissible from impermissible actions? Again, people are manifestly able to draw those distinctions. You can show experimentally that people can make moral judgments about many cases, perhaps an indefinite number of cases, including new cases. And so they're somehow projecting some system they have in their mind to this novel fact pattern. In the law, we call that cases of first impression. In the study of moral psychology, we can control that idea and use it as part of a research program to ask, how do people project their knowledge to new cases? And the answer to that question we might call a moral grammar. So we're attributing to the mind some system of rules and principles that explains and predicts their moral intuitions. In the bottom of the chart, we have the acquisition model, both for language and morality. And what Chomsky and other linguists showed quite decisively was that the linguistic grammars that children acquire are underdetermined significantly by the evidence that is available to them as language learners. This is essentially Plato's argument in the Republic or in the Meno, other classical texts, when Plato sets out to prove to his companions that an untutored slave boy knows principles of geometry. He does that by extracting that latent knowledge by asking questions of the boy. And the implicit argument is the information that the boy has been given through explicit instruction or in the environment is not the exclusive source of his knowledge. He must have innate knowledge of geometry, and Plato says of other subjects like ethics and justice as well. And what Chomsky showed, I'm prepared to say, or proved to a high degree of plausibility to the scientific community, was that the acquisition of language looks like that. It is significantly underdetermined by the evidence available to language learners. So that's what he calls the poverty of the stimulus. And it's for that reason that scientifically we're entitled to postulate innate linguistic knowledge. That's what Chomsky calls universal grammar, UG. Now, UG has to have specific properties. In particular, it has to be rich and specific enough to explain how each child gets over the learning hump, interacting with the information from the environment. But it also has to be flexible enough to explain how any human child can acquire any of the world's natural languages. And so that's what gives the study of universal grammar a lot of intellectual interest. It's a very hard problem to state a set of principles that somehow can explain the acquisition of all of the world's languages, as well as how actually the acquisition of language works in the case of a given child. So the postulation of innate knowledge is not meant to deny linguistic diversity, but on the contrary, to explain it. Now, this is very important when we come to think about moral cognition, because there's a natural, easy assumption that if someone starts talking about a naturalistic basis to morality or moral cognition, they're somehow denying the influence of culture. Quite the contrary. One natural implication is that the system will unfold in much the way that language unfolds, which is to say it will take on different forms in different environments. But if the poverty of the stimulus argument is sound, if we can point to properties of the moral grammars that children acquire, that each of us acquires, that are not derivable exclusively from the environment, then there's a basis to say there's something like a universal moral grammar, some innate moral knowledge that's entering into the acquisition of a mature moral competence. And as scientists, we'd like to know the answers to at least two questions. How much diversity is there, in fact, in the moral grammars that individuals acquire? And how much evidence is available to them to acquire those grammars? So it's a straightforward empirical question. There should be no dogmatic a priori assumptions. We just have to find out what the answers are. And this is the way science works. We can have hopes and guesses and inclinations, but we have to find out what the evidence suggests. So now let me suggest to you that there is at least some evidence which makes the universal moral grammar hypothesis plausible. Not conclusive, not necessarily true, just plausible. But maybe more plausible than contradictory alternatives. So the study of moral development in young children has suggested, to me at least, that young children are what I call intuitive lawyers. What do I mean by that? I mean that if you study kids using a Socratic method and ask them to give you moral intuitions about fact patterns, the best explanation for the intuitive judgments that they will give you is that they're relying unconsciously on legal rules. So it's an attempt to say Plato was right in some respects. So for example, 3- and 4-year-old children draw a distinction that's quite similar to the distinction that we draw in the law between mala in se and mala prohibita. Certain acts are intrinsically wrong, and other acts are wrong because some authority figure decided that they are. 3- and 4-year-olds use intent or purpose to distinguish two acts with the same result. Well, so do legal systems. So do we in everyday legal judgments. That's another interesting discovery. 4- and 5-year-old children use a proportionality principle to determine the correct level of punishment for principles and accessories. So they're subtle in the way they assign blame and responsibility in multi-party conduct. 5- and 6-year-olds draw something like a mistake of fact, mistake of law distinction in simple cases, recognizing that false factual beliefs can exculpate, but false moral beliefs do not. So there's some evidence here that we see the emergence of a sophisticated intuitive jurisprudence in human children. And then the question is, how did that system get there? Is it natural? Is it conventional? Is it some kind of mixture of the two? More evidence comes from the study of deontic modality in natural language. It looks like most or all of the world's languages have concepts or devices to distinguish the three main deontic concepts that are so fundamental in ethical and legal systems, that of must not, and may, or forbidden, permissible, and obligatory. And deontic logicians, going back to people like Leibniz and Bentham and other more recent thinkers, have shown that deontic logic is formalizable. These concepts have tight logical interrelations. They form a system. We can generate statements on the basis of a deontic calculus. Legal anthropology and comparative law suggest that some prohibitions, some first-order prohibitions of things like murder, rape, and other forms of violence may be universal or nearly so. Distinctions like those we draw in the law all the time between based on intent, causation, and voluntary behavior also look to be human universals or near human universals. Legal theorists like George Fletcher have spoken at length about what he calls the universal grammar of the criminal law. That again, we see similar patterns and concepts used throughout the world in that area as well. And cognitive neuroscience is also, I think, adding some evidence to this picture. Researchers like Rebecca Sachs and Leanne Young, who are here depicted, and others, have done great work starting to ask much more precise questions about the neurocognitive basis of human moral and social judgment than have been asked previously. Questions like, in cases involving mens rea or intent or attempt, can we find regions of the brain that are selectively recruited for those judgments? This is far more sophisticated than previous research that didn't draw those kinds of distinctions. And they've found evidence which suggests that the right temporal parietal junction, one of the areas of the brain, is selectively recruited for those kinds of judgments. Another researcher has demonstrated, or suggested, I should say, that the superior temporal sulcus and the ventral medial prefrontal cortex are especially active when harm is the intended means of an action rather than a foreseen side effect. That's another quite subtle distinction that we use in the law. So I think it would be a mistake to turn away from this research and say it can't bear on the kinds of questions that we're interested in. I think it can bear quite helpfully, but it's certainly only one piece of the puzzle. My own research has been focused mainly on these fact patterns known as trolley problems. They may be familiar to many of you, these 5 versus 1 moral dilemmas. So in one case, classic case, a train is rushing down the tracks and it's about to kill 5 people. And the bystander who's standing next to a switch can do one action only, and that is turn the train onto a side track where it will kill the one person standing there instead of 5 on the main track. And the question is whether that's a permissible action. And then another case, a companion case, is what's called the footbridge problem. The question is whether one can, in a similar situation when a train is rushing down the tracks and about to kill 5 people, whether a bystander can throw another individual in front of the tracks, in front of the train, to slow the train down in order to save the 5. So from a utilitarian perspective, these look like they're equivalent cases. And in early research that I did with my colleagues Elizabeth Spelke and Christina Sorrentino, we discovered that ordinary people don't think so. They have strong intuitive judgments that distinguish the cases. So the first case where you turn the train is widely held to be morally permissible, and the second case where you throw the man is held to be impermissible. There are many cases that one can conjure up of this sort. They don't all involve trains. They can be biomedical cases, all kinds of cases. But the point is to see, is there an intuitive limit to utilitarianism? Do people, putting it in legal terms, do they apply a privilege or a justification of necessity, a choice of harm or evils principle that does not distinguish the causal means by which the outcomes are achieved, or do they draw a sharper distinction and thereby constrain the necessity defense? And it looks like ordinary individuals constrain the necessity defense, whether or not that's normatively justified. This is descriptive work, not normative, but we want to know how people make those judgments. Interesting point is that if you ask people to explain or justify their judgments, they're often incapable of doing so. So this takes us back to that Enlightenment observation that many thinkers made, which is that these sources of moral judgment are non-introspectable or maybe unconscious or semi-conscious, not easily presented by the individual herself when she's trying to justify or explain her judgment. So people say things like, I don't know why I distinguish the cases. Or they say, I know I can't justify this, but I just feel strongly that they're different. That's very demonstrable as well. So what are people doing? Well, again, the hypothesis that I've proposed is that individuals are intuitive lawyers, much as Holmes and other common law legal theorists have told us many times over. People decide the case first, and then they determine the principle afterwards, and they're not always able to articulate those unconscious major premises of their moral judgment. But what it looks like they may be doing is computing unconsciously representations of human action that encode the relevant moral/legal properties. Things like, what's the goal of the action? What are the side effects of the action? What are the means to achieve the goal? Am I doing something that's prima facie impermissible as a means, like committing a battery, as one is doing in the footbridge case or many other impermissible cases? Or is the impermissible action prima facie a side effect rather than a means? Those kinds of distinctions. And I've tried to show in many instances that this kind of hypothesis can explain a lot of data. It's not a perfect hypothesis. There are going to be counterexamples. It can explain a lot of data, and in particular, it can even explain the variance that we see experimentally. So it can explain the modal data. What do most people say? But also, when we see differences, we can trace those differences to properties of these unconscious act trees that I'm suggesting people are computing. And so this is just a slide that shows that in 6 cases, permissibility judgments increase linearly across the conditions, and I can point to properties of the act trees that may, in fact, be generating those differences. So again, the research it goes right back to Plato. It's the experimental version of the Socratic method, if you will. Asking people questions, seeing what their intuitive responses are, but the hypothesis, the strong hypothesis, is that they're going to be drawing on principles which are interestingly not obviously derived from their environment, or plausibly something that might be innate. And again, I just stress over and over, this is just a hypothesis. It's empirical. It could be false. We just have to see what the evidence suggests. I'm going to fast forward. This is some of the details of the research explaining how we can unpack computationally the steps of the operations. But let me just draw some contrasts and then wind down. Jonathan Haidt is an excellent social psychologist who's done a lot of work on what he calls a social intuitionist model of moral judgment. And to sort of see what the difference is between a cognitive science perspective and a social psychological perspective, one can look to Haidt's model. So Haidt also is quite interested in intuitions as a kind of foundational concept and how we reason from intuitions. But he does not give an analysis of how we go from what he calls the eliciting situation to the intuition. And that's what I'm trying to provide, which is that front-end computational process by which we appraise and evaluate the action, how we get our intuitions. Joshua Green is a friend and colleague who's done a lot of interesting work on the trolley problems, and he does it from a more straightforwardly neuroscientific perspective. He is drawing from a kind of dual process model of cognition, system 1, system 2, and he thinks that people tend to make their moral judgments based on the emotional characteristic of the action. So in the footbridge problem and other impermissible cases, people are following their emotions. They have a strong emotional reaction to the case, and in the absence of that emotional reaction, they default to utilitarian reasoning. And he's gathered evidence which suggests that this may be a plausible model. The criticisms that I have of Josh's work are twofold for our purposes. One is that the actual principles that he's stated, which purport to explain the judgments from an information processing point of view or a computational cognitive science point of view, are inadequate. So in his early work, he distinguished between what he called personal and impersonal moral violations, and he gave 3 characteristics for what comprise a personal moral violation. It's personal if it's likely to cause serious bodily harm to a particular person in such a way that the harm does not result from the deflection of an existing threat onto a different party. That sounds a lot like the trolley problem cases, right? And if it doesn't have those elements, it's an impersonal case. And the problem with that description is that it can't explain the data. It's very easy to line up cases which show that people must be doing something differently. Just as we would in an ordinary law school classroom, the first answer you give, or the second or the third, sometimes isn't accurately describing the rules that can explain the cases, and so too here. So something else is going on. And what is going on, I want to suggest, is again that people are intuitive lawyers. So in Green's first seminal paper in Science in 2001, it turns out that all of the cases, except for one, in his first condition, which he called the personal condition, and these are the names of the 25 cases that he used, all of those, except for one, were violent crimes and torts, cases of battery and homicide. So what I have suggested is that, again, all of this data can be explained, all of this behavioral data can be explained by assuming that people are intuitive tort lawyers, let's say. They're recognizing that battery is presumptively wrong, and unless the justification is of the right kind, the act is impermissible. And in all of these cases, the justification is inadequate. And it turns out that this kind of an explanation, I think, can explain a lot of research across the cognitive sciences, whether it's neuroscientific, based in child development, adult judgments, and others. So I leave you with this thought, going back to the last 2 questions that I identified in the first part of the talk. There are 2 questions now that we might start to be able to address, and it's the neurocognitive and the evolutionary question. If everything I've said is true or even plausible, we will now want to ask, how does the brain compute those unconscious representations that are explaining the behavioral data? And last, how are those computations and the emotions that they typically elicit related to the characteristics and the cognitive capacities of other animals? So thanks very much for your time and attention. I look forward to the discussion.
I believe that a neuroscience of human agency will reveal a new enlightenment. I have confidence in an empirical morality informed by neuroscientific insights, and I'll explain why. But first, I want to take account of the caveats. The reason neuroscience is undeveloped, or at least underdeveloped, as of yet. I acknowledge the limits of our tools. The variety of scanning devices light up nicely, but they may not be telling us what we want them to tell us. And of course, I don't think we yet understand what they are telling us. So not only can we not be confident that we see all there is to see, we cannot be sure that we understand what we do see. I acknowledge the persistence of what I refer to as phrenology think, reaching conclusions about characteristics and character by feeling the bumps on the subject's head or by examining brain scans. Isolating aspects of brain function and personality by reference to where the scan lights up is problematic and may ignore the impact of neural networking that we do not yet understand. Eric Kandel recognized this, but maybe we can generalize from the aplysia that he worked on. I also acknowledge the shininess of brain imaging and of science generally. fMRI scans are attractive and seem authoritative, the more so when someone in a white lab coat tells us what they mean. We tend to defer to even the appearance of authority. I assume that's one reason judges wear robes. Finally, I acknowledge the paradoxically Kierkegaardian leap of faith that science, too, requires as theory develops. There is an important difference between science and science fiction, as my students have to remind me from time to time, Baker. Just as in philosophy and theology, there is an intuitionism, armchair theorizing, so there is in science, too. Even Einstein acknowledged that relativity came to him as an intuition. Nonetheless, I do conclude that the neuroscientific perspective is valuable. Not so much, at least not yet, because of the answers it provides, but perhaps already for the questions it reveals, though it may help even now by confirming the answers provided by behavioral indicia. If cognitive neuroscience confirms or refines folk psychological observations and conclusions, then that too would be a contribution, I think. Neuroscience specifically, and the more empirical perspective generally, turns why questions into how questions. And we realize that once we understand how something works, the why it works that way dissolves or seems a good deal less important. When we discover a natural explanation, we have less need for the supernatural. When we find a brain lesion, we no longer need to blame aberrant behavior on demonic possession, and that's important. So neuroscience, by explaining how, recasts our conception of human agency. It exposes the constituents and limitations of our perceptions and memories, and the bases of our biases too. Keep in mind, we are continually telling ourselves a story. That's the voice that is in our head all the time. I'm not hearing them. There really is one there. It's a continuing narrative, and we do not always well distinguish fact from fiction or fantasy. Neuroscience also breaks down barriers between the mental and the physical, and between emotion and reason, as it accounts for the symbiotic relationship between heart and mind. Dr. Antonio Damasio's somatic marker theory has explained to us how we need emotion to reach correct, rational conclusions. Good science exposes dichotomies as continua, and that matters when the legal doctrine relies on dichotomies. Human experience is gray. It's analog, not black or white, not digital. So my focus in both of my brief presentations today is on the language and fundamental normative assumptions of the extant law, the vocabulary of legal doctrine, and its relationship to the normative enterprise. In these first remarks, I consider the terms of doctrine and the law's conception of human agency generally. On the next panel, I consider criminal responsibility in a world of empirical morality. So first, I maintain that neuroscience may reveal a normativity that better serves our interests by better appreciating the nature of human agency. I begin by agreeing with Professors Mikhail and Smith and some of their comments today, and also what I've read of their work. We do demonstrate, I think, a values instinct, and our legal doctrine does accommodate what Professor Smith has referred to before as smuggling of our values into the language of the law and legal decisions. Indeed, we like the law, as Fuller recognized, and legal language that constrains us the least, that best accommodates our smuggling of values. In general, the language of legal doctrine is deontological, or deontic to abbreviate. And deontology posits an intuitive and accessible sense of duty, of moral imperative, such as Kant's categorical imperative. Act only according to that maxim whereby you can, at the same time, will that it should become a universal law. Deontology is built, I believe, on a progression from emotion to morality. First, our forebears, 250,000 years ago on the savannah, had an emotional or visceral reaction. In the context of community, that became described as a morality. Their actions were moral if they were consistent with that emotional or visceral reaction. So I see morality as a rationalization of emotion. And that then becomes law, ultimately, as the codification of morality. After all, we wouldn't be comfortable with law that was immoral. Richard Joyce's The Evolution of Morality develops and defends that thesis. Deontic language operates as the non-cognitivists understood it would. That is, it has a motive effect, describes our affective reaction, but perhaps too often lacks a fundamental reality referent. Yet the deontic perspective fails because it is inconsistent with the reality of human agency. The brain's function, and necessarily then all of our function, is founded on consequentialist, not deontic premises, ultimately. That is not to say that consequentialist theory provides all of the answers. I do not think it does. Indeed, we rarely can do the consequentialist math, though we assume we can, and nor can we do the deontic math. In order to determine certainly what the result will create the most welfare or maximize whatever it is we have decided that we want to maximize, consequentialism will not get us there. We need, or are predisposed to feel that we need, a means to discover the object of human experience, the telos. We are predisposed to embrace the teleology. But we should not be disappointed, or at least not surprised, if we discover that the object is merely to continue the line, that is, something like reproductive success. What the Enlightenment was to theology, neuroscience, which represents reductionist, empirical, mechanistic normativity, is to philosophy and deontic conceptions of the human agent. That is, neuroscience, I believe, presents a grave threat. Descartes' substance dualism, the distinction of body and soul, the soul was supposed to be, though, immaterial, but in the pineal gland somehow, I would say, and the brain and mind today is an advance. Cartesian philosophy was an improvement upon the theologically supernatural, but neuroscience exposes all of dualism, substance or otherwise, and normative systems based on it as fantastic in the pejorative sense. The problem of law, then, is that the dualism of deontic vocabulary, a product of the Enlightenment, frames inauthentically what it means to be human for all of our legal doctrine. You see this in the constitutional law, particularly the Bill of Rights. Now I have tied the conference into the Bill of Rights, so it's a good expenditure for the Institute. Bill of Rights reifies a particular conception of the self, the inviolability of the constituents of our thought. So we can draw distinctions between testimony and physical evidence, but that breaks down from the neuroscientific perspective, or a more empirical normativity. Or at least it may. And it will help us little to ask what the framers intended, I think. They didn't even know MRI, much less fMRI. Criminal law relies on conceptions of responsibility, excuse, punishment, and retribution generally. The tort law distinguishes mental from physical injury and reaches conclusions about competence in reliance on that mental-physical divide, which breaks down upon neuroscience's examination of it. And even contract, my own field, with regard to matters such as capacity to contract and the contours of agreement, indulges fictions that resolve controversy, but at some normative cost. Agreement is just another instance of what neuroscience may reveal to be a conclusion masquerading as an analysis. Indeed, to the extent that we come to understand more of contract by reference to willfulness, a movement in the contract scholarship now, rather than strict liability, neuroscience will have more work to do in the contract law. Distinctions that make sense, or seem to make sense, in a dualistic world, a world that distinguishes between our brains and something else responsible for our actions, the mind, perhaps, break down from the monistic, materialistic perspective. I have heard it said that brains don't kill people, people kill people. But neuroscience can, I believe, confirm that people are essentially no more than their brains. There is not one you that some other you controls. There are certainly judgments that you make and act on, but there is no such thing as getting out of yourself to make them. Ultimately, the you that decides is the product of forces largely beyond your control, in the sense that a Men in Black-like homunculus is operating in some control center and responds to an array of unbiased perceptions. Most significantly, this truth undermines conceptions of objectivity on which so much of law is based and on which virtually all of our interactions are ideally premised. Of course your action seems reprehensible to me if I'm asked to judge it. You have done the thing that I could never do, because in reality I could not do it. And even if an earlier I could have done it, that human agent no longer exists, at least perhaps not essentially and importantly in the same way. We are dissimilar in ways that are normatively significant. We are each the product of myriad forces beyond our full and unbiased appreciation. I cannot really feel your pain, Ben, not the same way you do. Empathy has its limits. I think we need to mine our legal doctrine for language and principles founded on deontic conceptions, and be, at least, suspicious of their operation. Emotivism, non-cognitivism can alert us to the usual suspects. Moral conclusions may be emotional reactions rationalized, not essentially anything more than that. Deontic doctrine is a normative system based on heuristics, the heuristics that translate emotion and intuition into rules of conduct. But there is a danger in failing to recognize and acknowledge the operation and limits of heuristics, and when and how they can fail. By definition, heuristics are shortcuts, and what they cut out may be crucial. It should not be surprising that heuristics that have served our interests in survival and cooperation, reproduction, should be, or at least appear, instinctual. That's why heuristics are heuristics. They are successful shortcuts, most of the time, successful and effective rules of thumb. It should also not surprise us that our legal doctrine seems to work best when it constrains us the least, when it instantiates those emotional, moral reactions. We see this in the frequent use of the term justice in contract doctrine, even explicitly used in the restatement of contracts, and reasonableness in the tort law. But neuroscience reveals the limitations of extant heuristics dependent on an ingrained folks' psychology. Terms such as justice and fairness and reasonableness and responsibility and blame and excuse appeal to our intuitions, perhaps because they encourage the release of oxytocin. There are questions that an empirical normative perspective presents. Can we do better once we understand human agency in more essential terms? Would it make a difference? I think it might for some of the reasons that Professor Mikhail suggested. Or at least rely on more empirical, or at least we could rely on more empirical measures to fill out what the intuitions and intuitious terminology suggest. Why would we be afraid of the more information neuroscience can provide, so long as that information is reliable? If we conclude that some of our legal doctrine, built on deontic conceptions, lacks a reality referent, we can either abandon it or recognize the need for elaboration. For example, in the tort law, what is emotional distress? What is it really, in empirical terms? Once we understand it and its physical basis, the law can better respond to it. We come to see that post-traumatic stress disorder is more like traumatic brain injury than some vague shell shock. We appreciate that so-called mental injury is just a particular type of physical injury, and specious but crucial distinctions between the mental and the physical break down, and that may matter so far as both evidence and the terms of doctrine are concerned. There may be no good reason for the tort law to take into account physical but not mental limitations of the tortfeasor. In contract, behavioral decision theory has demonstrated that assumptions on which contract doctrine is based, rational choice particularly, are deficient and do not provide the revelation of preferences crucial to a normative system designed to accomplish the welfare benefits of exchange. Neuroscience can confirm, as well as perhaps extend, behavioral decision theory, can confirm Kahneman and Tversky's two systems of thought and the relative unreliability of system one, the heuristic system, and the reliability of system two, based on analytical, more accurate analysis. But system two, though it's more accurate, requires more energy. So we are evolutionarily predisposed to use it sparingly and to rely on system one perhaps too often. At the intersection of behavioral decision theory and neuroscience, we can find consilience. E.O. Wilson wrote that we'll know we've found truth when different intellectual and academic disciplines converge on it. A preference for bottom-up rather than top-down analyses. Biology and chemistry and physics will provide answers sociology and philosophy and theology cannot. You see this already in the consilience of evolutionary psychology, cognitive neuroscience, experimental ethics in philosophy, situational ethics, empirical analysis in legal scholarship, even Moneyball, Nate Silver, okay, for that matter, replacing feeling for something more, or at least for something else that gives us more reliable information. In conclusion, what ultimately emerges from the more materialistic perspective is a new conception of what it means to be human. We are creatures, like all creatures, that skim the surface of reality through imperfect perceptual machinery subject to error. And that error may be exploited to realize results that would seem inconsistent with human values, understood in either consequentialist or non-consequentialist terms. The law should not be party to such exploitation, but should be subject to revision that would better police error. The language of the law has made us comfortable with our prejudices and biases about human agency. Prejudices and biases preserved by deontology that support our hubristic and ultimately erroneous belief in the very limited fallibility of our sense of self. Neuroscience can help us better appreciate the dissonance between legal doctrine based on that inauthentic conception of the human agent and the reality of human experience that the law must engage before it can serve our authentic interests, whatever we discover they may be. Now, we have time for questions. For the recording, I will repeat any questions that come, and our panelists will answer them. So please don't be shy. Professor.
Let's see. I'd like to ask two questions of Professor Mikhail.
Do them one at a time so I can repeat them here.
Okay. These are just laboratory questions. So I'm just interested in the analogy between linguistic and moral practice, and a couple of ways in which they practice this analysis. Linguistic judgments are plausibly either purely descriptive or at best thinly quantitative. You don't get in trouble for saying it's an apple spell when it's from this or who you come from. But presumably you do for moral judgment consequences. So there's one piece you want to the other doesn't. But more importantly, I think the linguistic judgment seems to me far less susceptible to stultification. I mean, we might have some utterances where we can't quite decide whether we think it's linguistic or not, but we have ways of figuring it out. But plenty of moral judgments, I feel, are just completely stultifying. We're faced with some sort of incommensurability, and we're just stopped in our tracks. Those seem to me pretty significant in this analogy. I just wonder what you think, and whether it might raise some questions about the absence of the etymology.
Yeah, and let me capture that. Professor Mikhail, could you elaborate on the distinguishability, or perhaps they are not so distinguishable, of moral and linguistic judgments?
Great. Well, that's an excellent set of questions. Just very briefly, the analogy that I'm most interested in drawing, or the set of analogies, are more theoretical and methodological than they are substantive. So it's not that when we get into the details of how linguistic cognition works and how moral cognition works, that those are going to be analogous necessarily across the board. There's some easy ways to see this. Moral judgments clearly require the representation of facts in the world, what beliefs are and actions and consequences and so on. and probabilistic elements, and the generation of alternatives to an action, and the comparison of the properties of an action against its alternatives. And none of those are elements of the properties that generate linguistic intuitions. In the book that I've written on the topic, what I do is begin with 9 comparisons between linguistic theory and moral theory, and they, by and large, have to do with sort of theoretical and methodological comparisons, like the questions that I identified, and how one might go about addressing them. So that's point 1. However, there are comparisons, interesting comparisons, I think, at the level of the judgments themselves and how they're experienced by the individual making the judgments. The phenomenological character of linguistic intuitions and moral intuitions have some interesting similarities. So both seem, to the person making the judgment, to have a kind of objectivity, a kind of mind-independent objectivity, even if the scientist might say, well, no, that's just kind of your way of cognizing the world. You think it's objective and it doesn't generate from your own mental capacities. But other judgments that we make seem straightforwardly subjective or to lack that objectivity. So that's interesting and I think worth taking a look at. On the incommensurability point, what I have argued is that actually there's much more incommensurability in the case of the world's natural languages than there is in the case of, let's call it, the world's natural moralities. People who acquire different languages in different linguistic contexts do not agree at all on the grammaticality of token utterances. In fact, they can't even pick out the word boundaries or the phrase structures of expressions in languages that they don't understand. So if someone gives you a token expression in Japanese or Arabic or Hebrew, Swahili, or any other language that you don't understand, you can't even tell what the words or the basic units are. That's a lot of incommensurability. Nonetheless, the claim is that these discrepant systems have emerged out of the same universal grammar. So there's the commonality, but instantiated very differently. In the case of moral judgment, what I've argued is that phenomena like human rights, like the fact that there are at least some basic norms of conduct that seem either universal or nearly universal, and that the basic elements that go into the representation of those actions likewise seem largely universal. So the fact that a crime has to have an intent component and an act component. That's part of the parsing that we do of action. And the analogous parsing that we do of linguistic utterances is already more diverse, more discrepant, more incommensurable. Nonetheless, I take your point. There may be genuine moral disagreement, and I don't have a great answer to how we move forward past that disagreement. In the book, I flesh out a long, complicated story drawing on Rawls's notion of reflective equilibrium and the idea that once we correct for performance errors, for false factual beliefs, for logical reasoning errors, and maybe for ideological elements that are not normatively entitled to respect, then we might actually have more convergence. I'll stop there. Happy to continue afterwards with more. Sir?
If I could follow up, I do believe that there is a moral convention as there is a language convention. But I think also that these conventions come out of what I think we call a universal class or community. And you have these variances within these communities morally, just as you would have them linguistically. But the question that I have, and I like to put this back to Mikhail, is when you have someone who would say bimoral, like a person who be bilingual, and say you have communities that have moral conventions, say like in Nazi Germany or the southern states of the U.S. in the 30s, and a person is able to assimilate between different communities and become bimoral, okay, then how does that speak to a universal morality when people are in fact able to shift as they have done, from one convention to the other relative to morality?
Let me repeat. Does the existence of bimoral persons threaten a conception of a universal morality?
Thanks. It's, again, a great question. So I would want to distinguish two ways in which there could be a universal morality, if that's the right term. And I think that these are probably not the most helpful terms. But one would be that in the initial state of the organism, the human genetic program, there would be what I'm calling a universal moral grammar. And as I've tried to explain, that claim, if true, would not preclude at all the existence of multiple moralities that are unfolded and developed and instantiated in each individual. If you want to get, sort of very specific about it, in the case of language, you might say that all human beings have their very own idiolect, specific to them. And actually, it's not going to be true that it's shared across a language community even. It's a property of that organism. And if one wanted, if you took out the microscope and could find individual differences, you might find those differences, just like we each have bodily organs, kidneys, livers, and the like, which are different in some ways. But from a scientific perspective, it makes sense to abstract away from those differences and talk about the human kidney or the human liver and the like. And in the initial state of that organ, its program, as it were, of ontogenetic development, the hypothesis is, the null hypothesis is that that's a shared state. So that's one sense of universal. Now, the other sense of universal has to do with whether the acquired moral competence of all human beings is similar enough that we might say that there are universal norms that obtain among, let's say, human adults around the world in different contexts. That's a very different question. And I have suggested, and I suggested today, that there is some modest evidence that there is what I would call more universality at that level of what is acquired, the steady state of moral competence in human beings around the world, than there is in the case of linguistic competence. Does that mean there's total uniformity, that there are no differences? No, I would not say that. Notice that the specific judgments that I discussed today were violent crimes and torts, battery, and homicide. And there's some evidence that when you look at those kinds of norms, they're substantially universal. I would not be prepared to say that the kinds of norms that Pete is interested in, for instance, in contractual obligation, that might also have a naturalistic foundation, misrepresentation, fraud, and so on, that one would find that those norms are likewise universal. I don't know. I haven't looked at the question, and I don't think there is as much evidence that there's universality there. But I would, just to finish, return to the notion of human rights. I think that if we take seriously the idea of universal human rights, then we are, in fact, postulating the existence of transcultural norms of conduct, at least in some cases. And we would want to know what's the psychological basis for those norms. Is there a naturalistic foundation for human rights? Or on the contrary, as theorists like Michael Perry and others have argued, there's no non-religious foundation for universal human rights. Either you don't believe in them, they're fictions, or you have to believe there's some kind of religious foundation. And I'm proposing a third alternative, which is there's a naturalistic foundation for the kinds of Use Kogan's norms, torture, battery. Battery is a lesser included offense of violent human rights violations and wrongs of that sort.
I guess if we can go back to the unity at the Big Bang, then there was universality that we've just been incorporating ever since.
That's Darwin's differentiation in nature, right? There's no denial of differentiation, but there's some universality there.
Any questions? Ron.
So when you say that there's a universal sort of morality or moral grammar, is that a potential for people to acquire sort of a morality, or is that just that everybody is going to have some sort of morality, whether or not there's a collective really moral or sort of stable in a moral way? Because when you talk about like 3-year-olds and 5-year-olds, they're already old enough to have sort of been socialized and taught the general social norms, and so that seems that would speak more to a moral grammar than necessarily just the quality of having a moral grammar.
Yes.
You want to repeat that?
Why don't you repeat that? I'm already on to the answer, I guess.
Okay. When you describe a universal moral grammar, are you talking about the capacity to develop normative or moral conceptions or some particular moral precepts? Is that close?
Right.
Okay. Okay.
Right. So I think that's a wonderful question, and I would describe it as the question of whether there's content, substantive content to the universal moral grammar, or whether that's simply a kind of a general norm acquisition device that could acquire any norms that the culture then would supply the content for. And that's a very good question. I think I would want to say we don't know enough to know what the answer is, although I think it is probative evidence that, again, some substantive norms do seem to be quite widely shared and do seem to go beyond the evidence available to developing norm acquirers, if you will. So notice that the kinds of norms that are going to be uncovered in this experimental work are not going to be so simple like don't hit, don't kill, don't steal, because the idea is that the cases that are presented to elicit these latent principles are going to require more complicated analysis than that. So just as in the law, where we might have a simple prima facie norm against battery, which is basically intentional harmful contact, but we're not going to find that people have a simple norm that says all intentional harmful contact is wrong. Quite the contrary, what we're going to find is that they deploy defenses, justifications, and excuses. And that's where things get interesting. So it's quite clear, and as a parent I can speak to this, that there's explicit instruction that's given to children about that prima facie norm. Don't hit your sister, don't hit your brother, and so forth. But what is not typically given in instruction is the kind of sophisticated parsing of the action that's a precondition for the application of more interesting principles of justification and excuse, or gradations of mental state. So parents don't typically instruct their children on the difference between intended and foreseen effects. That's subtle. They may talk about the difference between on purpose and by accident, but when you get a little bit more subtle, as we do in the law, the criminal law in particular, model penal code and so forth, now we're getting into interesting areas of what I'm calling intuitive jurisprudence, and the idea would be that that's the interesting case for an innate moral competence.
We are scheduled to have a break to switch over panels and have to get folks on, and I am predisposed to keep us on schedule, so we will break down and be back in about 6 minutes.